My name is Heidi Weber, and I'm a whistleblower. I'm credited with being one of the first women whistleblowers in the higher education industry to go through a long legal battle and survive a 7-day jury trial. That experience changed my life, and I'm on a mission to show America just how hard that battle is. After my story aired on CBS, I decided that I wanted to create a podcast that would focus on the journey of a whistleblower, the process, the daily struggles, and all the amazing people that surround them that help them along the way. We take an inside look into what whistleblowers go through each day and getting rid of all the negativity that surrounds that word so that we can get down to some real facts and genuine information. That way we can hold the corrupt forces accountable and help others find their voice too. Join us because this one's definitely no tea party. Support for the Whistleblower Revolution provided by
the Marion Scallard Law Firm. Our talented attorneys have been at the forefront of whistleblower law for decades. Our presence in Washington, D.C. gives us access to key government players while still allowing us to represent whistleblowers from across the country and around the world. Marion Scallard is committed to fighting fraud and protecting whistleblowers. For more information, please visit us at findjustice.com.
Hi, welcome to the Whistleblower Revolution. This is Heidi Weber. I'm your host. Today's guest is an icon, a whistleblower icon. He's an attorney who has had this amazing career. I'm so fortunate to be able to talk to him and just get a lot of information about his amazing career, all the things that he's done and all the things that he's done outside of the whistleblower world as well. So without further ado, welcome Bob Thomas from the Whistleblower Law Collaborative. Thank you, Heidi. It's great to be here, and I don't think I deserved that particular iconic status, but I appreciate the sentiment, and it's really an honor to be on your show, and thank you for putting this show together. You really have had an amazing career. You and Suzanne started the Whistleblower Law Collaborative, right? We did. It wasn't named that until recently. It was really just two sole practitioners operating effectively on a handshake for quite a long period of time. And then recently we decided to expand, which is part of a longer story. And when we expanded, we changed the name to Whistleblower Law Collaborative. And it's a fabulous name. I mean, you couldn't pick a better name because of just the warmth of it, that draws people in. It tells somebody that there's a whole bunch of people here that are going to help you, not just one. Right. We also like the name collaborative because we like to think of ourselves as working in collaborative fashion, not only with each other, but with our fellow members of the bar and with our clients. And you can be a bomb thrower or you can be a peacemaker. And, litigators are often accused of being bomb throwers, but, I think there's a lot that can be accomplished with the opposite approach as well. Absolutely. And so, Bob, what made you decide to be a whistleblower attorney? Mm-hmm. I ask everybody that, I think, when we start out, but what made you decide to do that? Well, it was a little bit of an organic process, I would say. I had been an assistant U.S. attorney doing white-collar fraud work in my home district of Maryland. Did that for about 8 years and found that work fascinating, but ultimately decided not to be a career prosecutor. And then I as I went out back into the private sector, I spent a few years sort of sorting through different options and landing in places that were good but not great, but sort of kept my antennae up for good opportunities and meaningful ways to be a lawyer, and stumbled upon I was doing some white-collar criminal defense work and found myself connected. Which is the opposite, right? That's kind of the opposite of whistleblower. Yes, in effect. But at the time, I was really just trying to find a way to make a living and support my family and so forth. And but what I noticed was
in these large healthcare investigations, many of which were based in Boston, out of the U.S. Attorney's Office here in Boston, there seemed to be a whistleblower who would emerge from behind the curtain at the end of the case and collect a big check. And I thought, well, that's a really interesting process. And so, I'm not embarrassed to say that I didn't know anything about the False Claims Act for the first half of my career. Even doing white collar criminal defense work, really didn't look at it much or have much occasion to look at it. And it was only when I was sort of sniffing around for interesting, creative ways to practice law as a sole practitioner that I started to put the dots together and say, well, this is really interesting work. It swims in the waters that are right at the confluence of criminal and civil. And that's been where I've been swimming for a while. And then I did a little more investigating and well, who represents these people? And it looks like a lot of them are former prosecutors in small firms. Well, that's me. And one thing led to another. And then Suzanne and I connected. And of course, she raised my game hugely because she had been the civil chief in the Boston U.S. Attorney's Office. I had done mostly criminal work in the Maryland office. So, no, we had met only as I was starting to explore this, and a mutual friend put us together, and we're both grateful for that.
Well, and for it to work like that is amazing. It's kind of like a work marriage, and for you guys to just mesh so well together is amazing.
Yeah, well, we have a lot of complementary skills and a lot of respect for each other, and it's been a wonderful experience all the way through, and we've I think had a ride that has been, at least from my perspective, more successful and more what's the right word I want? I don't know. It's just been it's been a bigger practice than I ever imagined, and I pursued this because it sounded interesting, but next thing I know, I'm on a moving vehicle that's going pretty fast.
This is a question I've wanted to ask a lot of whistleblower attorneys. So I'll ask you and we'll see. And then we'll get into all the other things that you're doing right now. Cause you're like me, you're like a gig person where you got 100 different things in the fire that maybe kind of tie together, but they don't.
Mm-hmm.
So here's my big question. How do you deal with you never know if you're going to win. You never know if you're going to get a paycheck. How do you work around that? Because it's not steady work. You're working on a contingency mostly. So
right.
How does that?
Well, it's a great question, and the what you ask in that question explains why there aren't more people doing this. It's not easy. It's very speculative. It's almost analogous to venture capital in the sense that you may have a lot of good ideas and a lot of acorns to plant, but not all of them are going to sprout. And it may not be logical why the ones who sprouted or the ones who didn't. And so you can have a great case and do a wonderful job of screening it, and you may find out 2 or 3 years in that you're not first to file, or there's a public disclosure problem, or that a factual assumption you made in the case isn't actually grounded in reality. And you can have done everything right and still not have something reach the finish line. So it's much more speculative than many other types of practices. So what attorneys in this space typically do is in the first few years, they've got to have some other system of supporting themselves, whether that's a spouse who has a lucrative job or some savings, or some other types of legal work that they're doing on the side. So I had in the beginning, I was doing some hourly work. I represented a union in an anti-corruption effort. I represented the Boston Red Sox for a while. I mean, there were a number of things that I did to sort of keep the lights on and keep the family fed, as it were. While we waited for some of those initial things to come in. And then later, when they come in, you have a little bit of a nest egg to work with. One of the things that's tricky about it is that when you take this on, you scare away other business. So when you declare yourself to be a whistleblower lawyer, you're not going to have a lot of corporate clients. Although interestingly, I will say that a couple of, I would say, highly evolved places have occasionally reached out to us to say, well, we could listen to what a defense lawyer says about all this, but hey, would you advise us on this situation? And so, who better than a whistleblower lawyer to tell you what is sensitive about how to handle an employee complaint, for example, right? I mean, I can tell you a slightly different perspective from what a defense lawyer could tell you about how it looks on this side and what that person is likely to be thinking after they get fired. And that's valuable information. So, yeah.
That's really interesting, Bob. I don't think any whistleblower attorneys ever said that phrase or come at it from that point of view, that what somebody may be thinking, because getting fired sucks. It totally does. Well,
and we have to be in communication with employment lawyers because so many of the universe of whistleblowers come from the world of either insiders or former insiders, recently departed insiders. And so many of these people are picking themselves up, dusting themselves off, figuring out what train was that just ran over me. And they might be talking to an employment lawyer first to figure out, what do I do with this severance agreement, or do I have a claim against these people? And we spend a lot of
non-disclosures, all that sort of
thing. Yeah, and we spend a lot of time with employment lawyers making sure that they know about this other set of options, because every once in a while there's going to be a person who comes along who got fired purportedly for some reason, but the real reason was the fact that they were on to something big that was embarrassing to the company. And we try to make sure that employment lawyers know about this other set of claims potentially out there
ahead of time. So you're working with them, before a whistleblower claim comes about even.
Yeah, just as part of our networking and our bar association kinds of outreach, we do blogging and various other forms of communication to.
No one wants to be a whistleblower. I don't think any of your clients set out to be a whistleblower. I did not. I didn't even know. You know what a whistleblower is, but you don't really know the legal.
Yeah, I mean, I think as a general statement, that's right. There are occasionally people who sort of come at this as a business plan, and we treat that with a certain amount of suspicion. But most whistleblowers, I agree with you, are reluctant to be in that status.
Well, and the thing is the statistic. I think it's. I'm averaging, of course, the statistic, but it's 80% of whistleblowers get nothing, zero. No payout, and still would do it anyway. That's the part that I love, is like that they would still do the same thing no matter what.
Well, so one of the things that is both important and inspiring about this work is the process of screening these cases and checking out people's motivations, because the motivation part of why they're coming forward is a good indicator of how they're going to hold up in a difficult process. So as we screen cases, let's say there's something that comes in that seems like a good claim. If it's clear to us that this client is really all about the money, that we need to have a conversation, because there's so many ways a good case can run into trouble that it's just not a healthy approach to be thinking about this from the monetary reward as your primary goal. The people who do best in this are people who are motivated primarily by the need to fix a problem, and maybe the money is a tipping point for them to make that decision. Maybe that helps them balance out the other risks in the equation. But if it's the primary motivation, it's going to be very hard to manage this person's expectations when the bumps in the road come.
And there are, the average whistleblower case is 3 to 5 years from the time you begin till the time you're done. And it's hard. I mean, that road, you're blacklisted. Although, everybody has this they're not sure if that's a real thing. It's a real thing. It is totally a real thing. But so you're, trying to make ends meet can be stressful for the client too.
And if it's the False Claims Act, if there are other whistleblower programs, but if it's under the False Claims Act, the matter's under seal. So you're subject to a court order that doesn't let you talk about it. So you can't even get the normal social support that you would in other stressful situations. It puts a lot of pressure on the lawyers, puts a lot of pressure on the spouses.
Yeah, I probably drove my attorney crazy, calling him, what's going on? What's happening now? What do I do? How do I handle this? So
yeah,
I think we became very good friends. I mean, I think, well, I hope he would call me his friend at this point because I'm not his client anymore. But
right.
You have to have this like mix, So do you find that with your clients? You have you kind of have a mesh or chemistry that works together?
Yeah, every situation is different, obviously, but there is certainly a unique chemistry to every case. And usually our cases are staffed by more than one attorney. So there's usually two, sometimes even three of us on a case. But the client relationships is critical. And managing the client's expectations is just a huge job. Because, as I say, there's so much internalized pressure, and there's no outlet for it because of the court seal, and so we spend a lot of time. I don't want to be pejorative in using this term, but we spend a lot of time holding hands, reassuring people that it's going to be okay. These delays are normal. You shouldn't read too much into this situation. We've been here before. And yes, it's not moving as fast as we would like, but it is moving at the pace that these things typically go. Those sorts of things.
You really made a point there. And I think we're expecting everything to be immediate. We just want this to be over. We want to bury it, send it away, mail it off.
Yeah.
And I think, my attorneys, I remember him saying that over and over to me. It's okay, Heidi. And then once things get going, they'll go a little faster. And as the wheels go, it'll get better. So, and then it's all this hurry up and wait,
Yeah.
file this 90 days and then wait. So you teach at the university. You teach a whistleblower class, which there isn't a realm for whistleblower attorneys, is there? It's not a specialty per se. It's just kind of
no. So the way I got started in this, this is at Boston University School of Law, which is a very, very good law school, and I was at my desk one day and got an email from a professor there inviting me to consider teaching. And when I talked to him, he said they have a health law program, which is a unique and very good feature of the law school. And they said, we realized as we were teaching this that the most important topic of this, or certainly a critical component of it, was something that we weren't able to teach, and that was fraud and abuse, healthcare fraud and abuse. Where they were teaching transactional matters, and they were teaching, various aspects of organizational structures, and it's just sort of more from the relationships of who are all these organizations, how do they work, and how do they intersect with each other. But the 800-pound gorilla was all the law enforcement activity around, healthcare, the healthcare economy. And so they sent out emails to all the prosecutors they knew, and sent out emails to all the defense lawyers they knew, saying who would be good to teach this. And according to what they said, I was the only name that appeared on both lists. So I was flattered by that, and as coincidence would have it, I had been thinking to myself that I wanted to get back into a classroom. I was briefly a teacher before I went to law school, so I was toying around with the idea, and then this email came. So it seemed like karma in some way, and that was 11 years ago. So I started this course called Healthcare Fraud and Abuse. It's been a seminar that usually has about 12 to 15 students every year. It's just been a blast because, first of all, I really love the interaction with these very talented young people. That's a lot of fun. Number two, it keeps me current, and gets me up to speed on some things that I didn't necessarily know as well as I might have. That's been useful in any number of ways. And then it's just developed into really a long-term set of relationships with my former students who are all now out there practicing law, and that's great fun. And then started a second course this fall that wasn't so narrowly focused on healthcare fraud and abuse, but was more on whistleblower laws and practice in general, because there are many other laws, whistleblower laws, other than the False Claims Act. And the other thing that was happening was that the final years of the Trump administration were just extraordinary in terms of the number of whistleblower complaints that were coming out of government, and it was almost a case study of whether these laws are working or whether they're protecting whistleblowers and so forth. You may recall that the first impeachment case was based on a whistleblower complaint, and there were a lot of efforts of the Trump administration to try to out that person, to try to retaliate. So I went to the faculty, the dean at BU, and I said, please let me teach this other whistleblower course. And that turned out to be just a really great experience, even though we ended up mostly remote on Zoom. But it was just an amazing time to teach it, because every week there was another inspector general getting fired or another whistleblower coming forward. So the relevance of the course was just obvious to everyone, and we just had a great time. And as I think you saw, I ended up on a Zoom call with Daniel Ellsberg and a student, because the course started with the first modern whistleblower most people think of as Daniel Ellsberg with the Pentagon Papers. So that was the first class, and one of my students came up and said, I actually interviewed him once, and I'd love to work that into a paper and stuff. And so anyway, we worked on that project together, and next thing I know, the three of us are on a Zoom call, and that was a very powerful experience for me, because I had studied the Vietnam War as a young person, and it was a great deal of fun to actually meet someone who I remembered from the 1970s as being a history-making individual.
And he's just, I hear anyway that he's just the nicest guy.
He's very, very nice guy, and sharp as a tack. I mean, I think he's in his 80s now, and wow, he was really on top of his game, and an impressive guy.
That's amazing. Those are the heroes, for us too. As a whistleblower.
Well, he literally risked his life. I mean,
he did.
What he did in that era, I would have to say, was a life-risking move. And he did get prosecuted, and he did get convicted, and the conviction was overturned, or I may have the sequence slightly, or maybe he was mid-trial when they declared a mistrial. But he was very much in harm's way for simply trying to tell the truth.
And the thing about him is his demeanor. Women always look for the body language, and men listen to what's being said. So I always think of that, when I was teaching school, I always think women they're not listening so much. They're looking at, okay, what's that body language, and reading that. And men are oblivious. They don't have any idea. They don't look at body, like they're listening to what, so, and that both aspects are equally as important. And watching some of those old tapes of him when he's testifying and things like that, his body language is so strong.
Yes.
And but he's not egotistical or anything. Like, he's just very strong framed. And
well, there's a perfect example of where the moral core of what was motivating him is what got him through, an incredibly difficult process. If he had been motivated by, let's say, a need for fame or a need for money, that pressure would have been too great. But what sustained him through that was the knowledge that he was right and that the public needed to know this. And if that's where you're coming from, you've got something that will withstand a lot of other pressure.
Exactly. You just nailed it totally. And talking to other whistleblowers, it's easy to see I get a lot of calls from people that they just don't know what to do. They don't even know there's a whole legal thing behind this. They think that it's going to the media and so when I talk to them, of course, there's nuts out there. There's some people that have some issues with being kind of a little crazy, know a lot of crazy, or just mental illness, that sort of thing, paranoia. But there are also people out there that the real whistleblowers, and you can tell them your screening process. I'm sure by now you can probably look at somebody, Bob, and tell what their motivation is without hardly going any further.
I mean, yeah, you still have to dig into the details of the claim, of course, but yeah, the initial impressions are revealing, and but they're not always enough. It's more than speed dating. You've got to say, well, let's look at the evidence you have and all of that. But certainly, I mean, where it gets interesting and tricky and where reasonable people can disagree is, okay, what if you have a person who comes in who appears to have a really good claim and a lot of evidence to back it up, but also shows signs of being interpersonally very difficult to work with, and that happens. And I don't want to sugarcoat it. Not every whistleblower is easy to work with. That's not the way humans are wired. And sometimes some of the personality traits that make people difficult are what makes them want to stick it to the man or stick it to the system, And so, right. That's all part of the package that we all have to look at and evaluate. I think as when we were first starting out and really looking for good cases and not realizing maybe that 3 to 5 years would be on the fast end of the cycle. Sometimes it's 7 or 8. The notion of having a person who had a good claim but a difficult personality, well, okay, let's go for it. Now I'm not as clear. I'm in my 60s, and I'm going to be working with someone for 10 years. I want someone that plays well in the sandbox.
Well, and especially you got to think, not obviously 99% of cases don't go to trial at that point, but what if you go to trial, you don't want somebody that's, maybe not going to portray the best image to the jury type thing.
Yeah, I think that's always a factor. We take that as an assumption that that at most the client will be there's always going to be fertile cross-examination of a whistleblower based on their economic interests alone. Okay, and if they have a tricky personality, well, then there's even more cross-examination fodder. So both we and the government look to put cases together in a way that ideally doesn't even need the whistleblower as a witness. The case shouldn't rest on the whistleblower. The whistleblower should open up the door to where all the evidence is, and then the evidence should lead you to the successful package. So many successful cases, even ones that go to trial, don't necessarily involve the whistleblower taking the witness stand, which is pretty cool when you think about it, because that's, there are documents that tell the story, and there are other witnesses that tell the story. The whistleblower put the claim together and put the theory together, but that doesn't mean necessarily that they need or should take the witness stand.
You're right. I never realized that they didn't, there are cases that wouldn't be that way. But it makes sense, because you're not, like you say, you're not going to have somebody who's always maybe comes off as being genuine or whatever, the jury doesn't like them, that sort of thing, which leads me into the strategy behind all these cases. There really is a strategy to legal. I didn't know anything about legal stuff. I worked in healthcare. I was a practitioner, and your specialty is healthcare fraud. That's one of the things that you've done over your career. But the strategy, like there's psychological strategy. There's all kinds of different things that you guys look at, not just the law.
Yeah, and sure. I mean, these cases are different from other cases because of the seal and the fact that they start off as government investigations. So yes, there's a claim in court, but it's filed under seal and it's not served on the defendant. So As a result of that, it really starts off as an investigation that we hope will go somewhere, even though it's pled as a lawsuit. So, I think we don't really think of it quite in the same way that, let's say, a plaintiff's tort lawyer would think about, a case that's going to immediately get into discovery and so forth. This is more, all right, let's get this to the people whose dollars are implicated, namely the government, okay, and get it in front of them, see how they react, see what they think of this theory, see how we can help them investigate it. And then if all goes well, it may never get into the courtroom. So it's a very different kind of strategy than you might undertake as a plaintiff in another setting that doesn't have that court seal in place. So the strategic considerations that enter into our thinking are things like which one of the 93 federal districts should we bring this to, and why? There might be nationwide venue, so we might have 93 possible choices, but there's a vast range of capacity in those 93 U.S. attorneys' offices, and it is part of our job to think strategically about, well, which one of those would be a good place to take this? Where do we have relationships and connections with people where we can vet this? So that's one thing. Another issue is things like some of the law under the False Claims Act has developed differently in the different circuits, in the different federal circuits. So one circuit may be a little bit tricky on first to file issues. Another circuit might be a little bit tricky on public disclosure issues. Well, we actually have to track all that so that we think about, well, we'd love to file this in New York, but the Second Circuit's bad on this particular issue, which is a big issue in this case, so let's file it somewhere other than the Second Circuit. So you have to do those kinds of things that are, I would put that in this. So not so much about, how's our client going to hold up on the witness stand, but more how relevant is this theory? What prosecutor's office is going to jump on this? And are there any legal landmines?
What are the judges like? What do they think,
although there again,
what are their stance?
Yeah, the only way that the judges sort of surface right away, and again, this is a difference between these cases and others, is how quickly do they want to unseal the matter? Because it's an investigation, not really an active lawsuit right away, they don't do much initially except look at seal extensions and hopefully grant them. But there's a wide variety of difference across the country in how quickly judges unseal matters. And that's something that we have to look at too. Some districts are notoriously fast, others are more slow. And the advantage of a fast seal unsealing is that it motivates everybody to work harder and faster. The much greater disadvantage is it often means the case gets unsealed before its time, and that can cause a good case to get dismissed or not intervened in by the government.
Wow. Do you have cases where you're into it quite a ways and it gets dismissed?
I wouldn't say it gets dismissed by it won't get dismissed without a whole series of conversations, let's put it that way. So we can be well into a case, and usually we try to stay informed with the prosecution about how this is all looking, how's it going, do you need any help, what's working, what's not working. But let's say they get to the point where they decide for whatever reason they're going to decline. Under the statute, we have the right then to go forward if we want to. So that's the key moment when we have to have a hard conversation both with the government and with the client about what do we do next. So they might decline, but that doesn't mean it's the end of the case. We now want to look at, well, why did they decline? Was it on the merits, or was it because they were short on personnel? Did the judge put too much time pressure on them, and so they just couldn't finish it? Sometimes it's something as benign and case killing as the assistant U.S. attorney, leaves the government and goes to make money in a private firm. And then you get a new prosecutor on it, has to start all over. And then it happens again, and now you've got a third prosecutor, has to start all over. Now the case is old. So that's nobody's fault, but it's a hazard in these cases. So there's a lot of things that have to be monitored and engaged with. It is not the case, as some people on the defense side seem to think, that we just file stuff and then go take a nap. It is not at all that way. It's busy because we have a lot of work to do to make sure that they understand what we've just delivered to them. There are going to be things that they need explanations on. They're going to want to interview our client. They're going to want documents. They're going to sometimes want our clients to go undercover. There's a lot going on. And also, sometimes our clients are still employed at the defendant's place of business, and we may get a real insider's view on how the company is dealing with the investigation. Are they dealing with it straight up, or are they playing games? And boy, that gets really interesting when, let's say our relator client has given the government documents, and now the government goes and subpoenas the company for documents, and the company produces documents except for all the hot ones that we've already given them.
Yeah.
Well, that's a real sign that something's going on. Either there's a defendant client who's not communicating very honestly with its lawyers, or there's some sort of gamesmanship happening. But that's the real advantage.
What do you do with that, or how do you deal with that? Do you get a judge involved right away? Do you compel them? I don't.
Well,
how do you do that, or how do you
no,
fix
because that would sort of tip everybody off that someone's whispering in the government's ear. So it's more likely that the government would simply put pressure on them and say, are you telling me there's no further documents? Well, and if they say yes, then you say, okay, well, what about this one? Why didn't you produce this one? And now that's a time when the defense lawyer should sort of have a little woodshed talk with the client about, okay, what's going on here?
Come to Jesus. Yeah. Right.
Yeah. So there's all manner of human behavior in these cases, good, bad, and ugly.
I asked this of Vincent McKnight, and I think I just asked this of Cleveland as well, Cleveland Lawrence. Why aren't there more criminal prosecutions for these people? Because as a whistleblower, your name's all, my case was different. My case was a state case. It was under whistleblower law, but it was a wrongful termination case. But so mine is different than the federal. But even so, these people are making these poor decisions. There is somebody driving the bus. Why aren't they ever held accountable?
Well, it's very tricky. I mean, a criminal prosecution, particularly of a lawyer, is that is a steep hill to climb. And in these complex white collar matters, there's a million different explanations of how some document that should have been produced wasn't produced. And those explanations can go from very benign to very sinister. And where it is on that spectrum is going to be a very involved process, because among other things, you're going to have to somehow get a window into things without violating the attorney-client privilege, which is very problematic.
Even like the CEO, even looking at it from a bigger scheme, it's very, most whistleblowers, we believe in justice, and we want to see fair things done, and it's not money driven like everybody thinks necessarily. But why, in my case, there was a leadership person who had made these decisions that were poor and illegal and fraudulent, and why aren't they held accountable? It seems like we just have this whistleblower case, and this one person skates away free and does it again.
Well, that's the ultimate and most challenging question in all of this is, you see a lot of corporate resolutions and a lot of money being paid. You don't see as much individual accountability as you might, and that's part of the reason why the conduct keeps happening. Now, in defense of the government, it's not as easy to hold individuals accountable, particularly criminally accountable, as it is to hold a corporation accountable. So with the corporation, you can aggregate all the evidence and say, look at all this stuff that we have on you. You can't do that with an individual. You can't blame the CEO for something that only the COO knew about. And so there are levels of insulation between the top people and where the conduct is often that make it hard to prove. And to your point, there have been a lot of efforts to go after individuals, and there has been a much more decidedly mixed record of success on that front than there has been of going after companies. But it's the question that I always pose in my class every year. It's like, okay, we recovered $3 billion for the taxpayers this year under the False Claims Act. The problem may be a $100 or $200 billion a year problem. Okay, so it's not like that $3 billion has stopped the problem. We are recovering more each year, but it's not of a scale that is really slowing it down. What would slow it down is if the decision makers had a liberty interest at stake. But it's not easy to indict people and convict them unless you've got really, really strong evidence. These people have, they work in large organizations. There's many layers of accountability that can be, you can shelter yourself and say, well, that's that department. I didn't know what that department was doing. And
they went rogue. I didn't know what they were doing.
Yeah, and so you have to then say, okay, what's the evidence? How can I pin it on someone higher? And you have to really get into the emails and the documents and the testimony of whether somebody knew and approved things. And it's very involved. And the government, not surprisingly, has had a tougher time making it stick. And so that makes it easier in some ways for them to say, well, the company's offering up this, huge amount of money. Let's take that and declare victory. And that's great, but is it enough to slow down the conduct? I mean, I can give you any number of examples of cases where the people who really knew what was going on and were really responsible for it are still there, even after the company has, paid a big.
Right. A lot of times the money sounds unbelievable. To think of, $1 billion case, that sounds unbelievable to the average person, when in reality, in the corporate realm, there's such a divide between, the corporate money.
Yeah. And
there's such a divide. It's a drop in the bucket.
Yeah. Not every company is the same, of course. I mean, some are more flush than others, but in all cases of this type, whether it's a company that has tons of cash or not, in all cases, it's still the shareholders' money. Okay. And it's the shareholders who are writing this check. So it's not coming out of the CEO's pocket. It's not coming out of their stock options.
Right.
It's coming out of the shareholders.
It should.
Well, and that's really the question: is there a meaningful way for the individuals to have a little more fear of the process than they do? Because at the end of the day, if you know that there's some vast amount of money that will make the government go away, and it's the shareholders' money, it's OPM, other people's money, well, okay, that was a pain. We had to go through it, had to hire some lawyers. It was several years, but that upward and onward, let's move on. So you do occasionally see some of these big companies that have been through the process multiple times, and that shouldn't happen. You shouldn't have recidivist corporate malfeasors.
Especially in healthcare, for instance. Healthcare is close to my heart. The three things, this is Heidi's three things that should never be corporatized or profiteers, is education, healthcare, and the criminal justice system. Those three systems are, I believe, they're corrupted when you get profit into them. I've seen firsthand how patients are taken care of when there's profit over their well-being, that sort of thing. So,
yeah, I mean, one of the things that I like to do with my students is to ask them to address, sort of what are they seeing systemically from having studied all this, and invariably the responses I get reflect a certain amount of sensitivity to the fact that if we were starting from scratch, we probably would have different systems in place than some of the ones we do. The problem is getting there from here. In other words, we've got an existing infrastructure of how healthcare and other industries work, and changing it is not starting from scratch. If you change it, you're going to change people's expectations of how much money they're making, what their jobs are, who they report to, and so forth. But yeah,
that's a lot to bite off. That's a lot to chew.
Yeah, and the profit
it's such
motive,
a large system.
The profit motive is deeply embedded in American culture, and now that has become deeply embedded in our healthcare culture, which is different from how other countries run their systems. If you look at Canada, Cuba, the UK, any number of countries, I mean, it looks very, very different. Fee for service, which is what we have here, is not uniformly the case all across the world. And fee for service, which ends up leading to the fact that certain types of doctors can make 7 figures a year, and certain types of hospital administrators can, make massive amounts of money. I mean, they're doing important work. Don't get me wrong, but it's not necessarily compelled by the universe that those should be compensated the way they are. And the economic incentives are one of the things that gets people in trouble. I mean, you wouldn't do simultaneous surgeries to quote a recent case from up here. You wouldn't, as a hospital or a doctor, simultaneous surgeries if there weren't a very strong economic incentive to do that. I mean, who would think up such a thing? But only in a fee-for-service world would even somebody do that. Or one of the cases that I start the course off with is Dr. Fatah out in Detroit. He was an oncologist who was giving healthy patients chemotherapy. Healthy patients chemotherapy. Why would you ever do that? Well, obviously the answer is money, right? There's a hefty infusion fee, but you would not see a doctor behaving that way if you had if you didn't have a fee-for-service system. That would be someone who was, just crazy, right? And maybe you would still say it was crazy, but his motivation was clearly economic. You can get a lot of money by these infusion fees. So just tell these poor oncology patients who are actually in remission and fine that they still need chemotherapy. I mean, that's just a shocking case. Yes, he is in prison, but the question I raise in the course is, well, how is that even a possibility that kind of behavior can happen? And the answer is, it's how we've set up our system with these economic incentives.
Well, greed is a motivating factor for a lot of different people, but also the profiteer can drive competition. It can drive, increased. There are a few benefits to having some kind of competition or drive.
Yeah, I'm not anti-capitalist. I just think capitalism has good sides and bad sides, and people need to recognize both. It is not a cure-all. Neither is the market a cure-all, but neither is it uniformly evil. I mean, it's got good and bad aspects to it.
Well, and the pendulum swings back and forth. The older I get, the more I get these wise thoughts of how the world works. I'm sure of things are not always the same. Maybe 10 years from now, it's going to be the pendulum's going to swing the other direction, and so forth. And I think I'm scared for where we're heading, where the country's heading right now, but just as a whole. But, things are not always they're going to be the same. So right now, you and I are on the same page with that. I get, I think greed is an issue for our corporate realm and lack of integrity.
If you take the long view of history and there's definitely an ebb and flow to, unregulated capital, and then there are excesses that bring regulation of that capital to bear, both for the standpoint of fairness, but also safety of the public. And then eventually there's a backlash against the regulation, and there's the push towards, free up these poor businesses from all these restraints, and that prevails for a while until the next economic collapse or scandal, and then there's more regulation. So there's if you go back 100, 120 years, you see these cycles, and I don't think they're going to end anytime soon. I'm not enough of a historian to tell you exactly where we are in the cycle, but we're somewhere in that mix.
Absolutely. So, I talked earlier about all the other things that you do, and you mentioned that you represented the Red Sox at one point, and we talked about your teaching. What other things? What's your favorite? First of all, what's your favorite case that you ever had? Well, who's your favorite? Tell us a little bit about that. I'm interested to hear what you're.
I love the Amerisource case that we did. Mike Mullen was our client. I hope you get a chance to speak to him someday. He's smarter and better looking than I am, and he's got a great story. And I have to say that that case was interesting in so many different ways. But for me, the way it came in, the friendship that we developed over the course of it, the collaboration between all the different lawyers working on the case. There was even a BU law school connection, which was that at a critical early stage in the case, we were in the process of amending our complaint after the first debriefing of the client, and we were piecing together where the complaint could be beefed up, and it was because of the fact that I had been teaching this course that I knew a little bit more about the Food, Drug, and Cosmetic Act than I did 2 years earlier. And that was just enough for me to say, well, hang on. It was a kickback case. It started as a kickback case. But I
was going to say, tell us how the case came about for somebody that doesn't know.
So the case ultimately involved both a criminal prosecution and a Civil False Claims Act case that had to do with the company's manipulation of approved drug products to turn them into unapproved drug products. So they were taking vials of certain oncology drugs mostly, but and they were taking 10-dose vials that had a little bit of overfill, which is required by the various rules, the good manufacturing rules, and taking every molecule out of those vials and creating 11 pre-filled syringes out of a 10-dose vial. And then that created an extra vial, which effectively was cash that could be used to offer hidden discounts to people. So we had a kickback theory that all led to. But it was in unpacking the kickback theory that I started to realize that what I had learned in the Food, Drug, and Cosmetic Act caused my antennae to go up a little bit. And I said, well, hang on, we may have another theory, another legal basis. It's not just the anti-kickback. There may be a Food, Drug, and Cosmetic Act claim here because of the manipulation of the product. And it's now...
So an OSHA claim, essentially?
No, not OSHA, but that this is you're taking an approved product and you're turning it into an unapproved product because now the seal's been broken, the expiration's been broken, the traceability's been broken, all those things. So this drug product that's going out to these oncologists is not what it purports to be anymore. And these are sick patients getting this stuff. So the BU connection was just a piece of that story, which was, I might not have known to really plead the Food, Drug, and Cosmetic Act the way we did without teaching that course. So, I have the course to thank for making me a more alert lawyer on that. But mainly the story of the client, and just, he was a rising star at that company, and suddenly his career is just very abruptly ended, and he tried to figure out, as I said earlier, what train was that just ran over me, and why did it run over me?
Right.
And so that the answer to those questions eventually led him to us, and it was just
what year was this? Tell us again.
It came to us around
approximately
2010, and I think it's settled, and I'm going to get this wrong, either 2018 or 19.
Oh, we're not holding your feet to the fire.
yeah, but it was almost a decade, and he had a tremendous outcome, but it was a real journey, and he was really an ideal client, both because he was an insider, he was smart and savvy enough to be familiar enough with how lawyers work, that he was always very respectful of the fact that we had other clients, other things to attend to, and was just very appreciative of the time we put in. And that makes a difference when you can acknowledge what the other person's reality is. He was also incredibly patient with the process, and he got on with his life. So he didn't just hold his breath and wait for a payday for 8 years. He got on with his life, and that was a very smart thing to do as well. So anyway, it was just an amazing journey with the whole team of lawyers. It wasn't just me by any means. The Kellogg firm in D.C., and then Suzanne, of course, and we had co-counsel from California that were involved in it. There was a lot of people involved in it.
Hey there, thanks for listening in. Couple of things here. If you have a whistleblower story, or you are a whistleblower, regardless if it's an old case or not, go to whistleblowerrevolution.com and send me a note. I will get a hold of you personally, and anything that we talk about is completely confidential and 100% free. I want to help you find the right resources for what you need. So go to whistleblowerrevolution.com and tell me your story. I love hearing them anyway. Thanks for listening today. I need to put a disclaimer out there. I'm not an attorney, so if you have any legal questions or you're searching for legal advice, you need to contact one of them. And it just so happens that on my website at whistleblowerrevolution.com, there's a whole page of amazing whistleblower attorneys all across the United States that you can get a hold of to answer those questions. If you're just searching for regular information about the show, upcoming episodes, or you have a question for me directly, please again go to whistleblowerrevolution.com. Thanks again, and please join us on the battlefield next week.